Hello and thank you for joining in on today's training. Heart & Solutions is a proud provider of CE-eligible trainings for our counseling community. This training may be eligible for continuing education credit hours through either the National Board for Certified Counselors, provider number 7376, or the Association of Play Therapy, provider number 21-645. To obtain CE hours for today's training, be sure to follow the steps in the description below to find and take your quiz.
So welcome to part 2 of play therapy and the courts. I believe everybody was at part 1 or has watched the recording of part 1. Kate Haberman is back with us today, which we are very excited for. Just as a refresher for all of you, it's been a little bit since we had part 1. But Kate Haberman is an LISW, MFT, RPT-S. She has over 20 years of experience working with children and families. Kate is the owner and director of the Center for Foundational and Recreational Wellness, LLC, and has gained a specialization in trauma and attachment. So Kate is a registered play therapist, as well as a play therapy supervisor, a state-approved social work supervisor, and is certified in Theraplay and Filial Therapy. In 2019, Kate was awarded Play Therapist of the Year by the Iowa Association for Play Therapy. Kate works from an attachment theory, neurosequential development, and family systems basis. She has extensive experience and knowledge in early developmental trauma, parent-child relational dynamics, childhood trauma, and working with the court and foster care system. Kate utilizes her strong communication, attunement, and relational skills to aid clinicians in enhancing their knowledge of development and relational patterns, child-centered based play therapy, sand tray processing, and ways to increase confidence in clinical advocacy and testifying. In practice, Kate specializes in working with children and families who have been affected by trauma and attachment disruption. Kate serves as an expert witness and offers potential trainings throughout the state. Outside of work, Kate is a foster and adoptive parent, an adjunct professor, is married, has a 13-year-old daughter, and 9-year-old twins. So Kate brings an incredible wealth of knowledge and expertise with her today to this second part of the training. And Kate's going to spend some time recapping a little bit of part 1 and reviewing lots of the objectives that are combined in these 2 parts of the training today. So in part 1, we did spend some time going over the ethical responsibilities in court as a play therapist, starting to talk about your own fears, biases, opinions as a play therapist working with children, how to navigate our ethical responsibilities within that court system, as well as understanding those relationships and our responsibilities professionally as well in the courts, and how to just explain what your role is and clarify your identity so that you can set structure and limits and feel more confident in that legal system. So lots of things to get through today. I'm going to let Kate take it from here.
All right, thank you. Well, we have a small group this morning, but I'm hoping that this second part can be a little bit more of, I guess, more specific to any of the questions, concerns, or even situations that you are currently in, like a little bit more application or practical kind of navigation of the maybe cases that you have or situations that came up. I will review a little bit. If there's any point in the review that kind of triggers an idea or a question for you, please shout it out. We have the time to sort of get a little bit deeper into all of this information as well. So I think that and I don't want to bore you with a review of things that we've already covered, but it's really just a matter of like opening that door again and seeing if there's anything that we want to explore further. And then also thinking about some of the questions that were on the evals last time. There was a few that were brought to my attention that we for sure will address. But if there's anything that you remember wondering about, please feel free to bring it up. So we will, just kind of a reminder that the whole purpose and the reason that I'm passionate about this training, and I really suggest that that really therapists or play therapists consider my viewpoint, is because we all are asked to work with the system in some capacity at some point in our professionalism. And, from my experience, from my history, many people in our field prioritize how to steer clear of the courts, how to kind of avoid or step out of working within the system. And if you remember when we reviewed the ethics, kind of considering that it is our ethical responsibility to lean into how the system works with us and with our clients and how we can contribute to that. Thinking of just our own ethical standpoint, or what we believe our responsibilities are ethically, kind of the idea of advocacy, the idea of our clients' right to self-determination, the idea that our clients often are in situations or are part of a population that are disempowered or have sort of lost their voice to be able to communicate, whether that's children or families or adults. And recognizing that we truly are the experts in this field. We're the experts about child development. We're the experts about play therapy. We're the experts about what maybe the system that we're working with needs, sort of a general expert at times, or just the expert of our client. And so recognizing that our ethical responsibility is to share that information and share that expertise, not just with our clients, but with the community and with the system, as a way to enhance that direct client that we're working with, and their access to services or their safety or their overall functioning. Let me just kind of check in regarding the ethical obligation. We won't go through that part again because I know everybody loves ethics a lot. But is there anything that you remember kind of considering differently or thinking more about when we did talk about the ethical responsibility of working within the system and with the courts? Is there anything that you remember kind of considering a different viewpoint on after this training, or it made you look at maybe an ethical standard differently?
This isn't so much regarding ethics per se. For me, the reason that I initially sort of signed up for this training was because I do struggle with that idea of like, I'm the expert. And so just having practical, like the practicals of writing a report and, kind of that validation and whatever, just for me, I have noticed a difference in my mindset since the first.
Like feeling more confident or feeling more like you know what you want to write or know what you should write?
Yeah, knowing what I should write, knowing kind of the basics of what should be included, and that and that I do know actually what I'm talking about, all of that good stuff.
That's great. That's great. So just kind of recognizing that there is sort of an awareness or a line that we do have to follow still about how much to add to a report or how much to put into a letter, but feeling like you have a better understanding of what those parameters are or what that structure is. And if you remember the activity that we did about, kind of imagining a statue to represent your expertise, right? So being able to a little bit more clearly about like, oh, when I'm asked to write about, this child's anxiety or response to stress, I really do know a lot about that. I really do know how to express that. And if I'm asked to write about a placement, or I'm asked to write about, how school is affecting this child, maybe that's not what I know much about. And so how do I really separate out where my area of confidence is or where my area of expertise is, and feel confident that I can write about that and not always answer all the other things or step outside of that line, for sure. Anything else regarding sort of the ethics or the standards, or just like, the principles that we do our job by, that you have considered maybe a little bit differently than maybe you had previously?
I put this in the chat, but there's only 4 of us, so I can just talk. It was helpful for me. Like a shift in perspective, and kind of reflecting on my role differently. But I still struggle with like balancing that client privacy, especially with children, and that possibility of having to testify to what they've shared, and also like how to just like talk about that with children. Because I know like I just think like if I were the client, I would probably disclose significantly less things, if I thought my parents typically would be in trouble for what I say.
I think you bring up a really good point, and I'm glad that you said it now so that we can talk about it more practically. Of course, every child situation is different. Every like sort of topic or question you're being asked is going to encourage you to look at things a little bit differently regarding what you need to share or what you think is appropriate to share. I think, some of the techniques that I've used, and I'll share these with you and we can talk about like the effectiveness or if you feel like that's applicable. But number one, often if there's a child that I know is, referred by DHS or is referred because of a significant trauma that is currently like under investigation, or it's going to be under investigation, or you just kind of know that that's a thing that's going to come up in some capacity. I do a lot of documenting in the session with the child so that it's almost like we have this progressive conversation about, these are things that are really important to remember. And I know that you probably won't want to talk about them again. So here's like a book that we're going to make, or a narrative, helping the child come up with a narrative if they're ready to. Again, I'm not going to ask them to if they're not going there. So it's not for like a disclosure purpose, or it's not for an investigative purpose. But if, again, I'm pretty direct in my sessions, but if it's a matter of, we're getting that place in therapy that we're starting to talk about what did happen, for my own clarification, and just for them to know that it's safely written down in their words in this book. And I narrate, like I write down what they have said, exactly how they've said it. And then usually in the next, couple sessions, as we've processed that, we review it. And we talk about like, these are your words. And so if this is ever something that, a judge might have to ask you about, or somebody else might have to, it's really important that they know that these are your words and nobody else's. And so I have them sign it. And I think all of that also adds to empowerment, right? It helps that child really take ownership of their perspective. And that way, I think, number one, we're not making assumptions, and we're not putting words or our own speculation into what they're doing. And I think it's a way for them to sort of have this anchor of what happened, right? So there's a lot of children that, court comes a year later, right? And they truly kind of forgot some of the things that have happened. And if anything, if I'm helping prepare them for testimony, like if that's part of what our job is to like, I know you're going to have to go to court and talk about what happened to you. There's some comfort in saying like, these are the words that you've shared with me. Are there things in here that you feel would be helpful to use in court? Or that you can take this book with you and you can read, because these are your own words. And then as a therapist, I'm testifying that the child disclosed these things to me based in their words. I'm not saying what they said. Like, I'm just agreeing, yes, I wrote down what they said to me. And at any point that child can take things out of it. At any point that child can add things to it. And it's not part of their public record. So it's not a part of their case note, but it's also helpful to me to know their story, whatever happened to them, their disclosure, but in a place that I don't enter that into any kind of legal record. It's their possession. It's their thing to keep. What I have found in the areas that I am in, they have been able to bring that into the CPC. They have been able to bring that book into court. And so I think that has helped them feel like I have the words to talk about. So that's one thing that I've done to sort of help them feel empowered, help them stay within their own words and their own story. And in my opinion, that's a way that I can support that empowerment without overstepping and speaking for them. The other thing to keep in mind, that at any point, if you feel, especially like if it's the custody case, and you know that if the child is going to say something, or you're going to say something that potentially could come back to hurt them at the, next time they see their parents, or it's going to be used against them, it's 100% appropriate, and most of the time it's respected, to say, I believe that answering that question would go against my client's best interest. You can say that, and you can say the child has asked me not to share that information, or my client has asked me not to share that information. And if you need to add in, it is my ethical responsibility to prioritize my client's safety and their needs and their right to self-determination and privacy first. So you're not being obstinate, you're not being, refusing. You're just making it very clear that ethically you have a priority. And it's very unlike, I've never been, well, yes, I have. I've been in a situation one time where the judge or the attorney overruled that, but one time. And then honestly, that judge recused himself from the case. So it had more to do with the judge than it did, So I feel like in that room, like in the courtroom with the attorneys, with the guardian ad litem, with the judge, if one person were to refuse you advocating for that child, it's usually something that's protested by someone else, because there is an element of protection for that child. And many people are not going to go against sort of the protected information, right? Because we are not the investigator. Even if the child discloses to us and we make the report to DHS, you can deflect to that. So I don't, if it's asked, like, on this date, this child reported to you in session that this happened, your response could be, I remember that date. I do not remember exactly what happened, but I do know that my ethical responsibility was to report it to DHS, and they have record of what I reported. And then your hands are clean from that. Like, because if you misinterpret, if you say something differently than what you said at that initial report, or let's say they said something to you and then when the DHS investigator investigated them, they said it differently, then all of a sudden it becomes like, well, what they said to you, do you believe that? Or do you believe what they said to DHS? And so I kind of look at that as like hearsay. So I'm not going to now repeat what that child told me, as long as I have done my due diligence of reporting it to DHS, because now it's documented somewhere else. So kind of shifting that responsibility. And I really think that those kinds of decisions to make regarding sort of when you carve out your path and you say, this is what's in my lane and this is what's not in my lane, that is what gives you credibility, right? And that is what helps the other people in the courtroom understand what your expertise is. Not everybody knows what a clinical social worker's job is compared to a state social worker. They don't know the difference. They just know you're working with this kid. And so it's up to you to set those parameters and boundaries when you need to in a system that may not be clear of what those are. I feel like there was another part to your question or your statement about that. Am I missing a part of that?
I don't think so. I think that was really helpful to talk about the privacy and how to talk to kids about that, and then how to stay in your lane with that as well. I don't know if this is relevant or you'll get to it, but I work with ages 0 to 8. So sometimes writing a book is not going to be a thing because they don't have words. So we don't have to go into that because I'm sure I'm the only one who sees that age group. But I don't know if you do have any tips for younger kids as we go through, that might be helpful.
Well, and I think that is a age group that I work with primarily too. So I think it's a very relevant question. Okay. And it's also relevant for the kids who don't want to write a book, right? Like they don't want to put words to it. So, I think the other thing I was sort of thinking about as well that you were talking about is just how to talk to the children about it in court or in your sessions about like if they're going to have a meeting with DHS, if they have to go to the CPC, if they have to go to the courtroom, what a deposition is, all of that stuff. So I have not yet found like a children's book that I really think is a simple enough discussion. So I use a lot of children's books, but I haven't found one about court or about DHS that I really like. I do have a sand tray set up of the courtroom. So I really encourage, even if you don't do sand tray, to just get courtroom toys. And I found mine, I think, on Child Therapy Toys or Marshall's Miniatures or somewhere like that. But it's a really good, they're just like plastic pieces that are like a jury box and the judge's chair. And so we sometimes just get those out and play court just to familiarize what that looks like. If you're familiar with child-centered play therapy with Gary Landreth, he has a technique that he uses for just kind of in general for anxiety for kids. And I find this to be really helpful for these situations where it's like an unknown or they don't really know what to expect. Their parent probably doesn't know what to expect. I think that's another time that we have to become the expert. So the more that you have gone through the DHS investigation, the more that you've gone to the CPC and looked around or built a relationship, the more you can share with them sort of what to expect and what things are going to be like. So often we use sort of this, it's like a storytelling technique. Gary would say to use like stuffed animals or puppets or some sort of doll and act out what the beginning is, what the middle is, and what the end is. And what their parent or what, if you're a significant person at that point, what you're going to be doing while they're doing those things. So that a lot of times it's kind of like, oh, but if this lawyer takes me into a courtroom and then I don't know where you're sitting, I don't know what you're going to do. Are you going to leave me there? Like it's all the stuff that they just don't, all those moving parts that they don't know. And so remembering that when we talk about that or we play it out, we have to think about all those moving parts too, because that's their world and that's what creates safety for them. So, for instance, if it's like going to the CPC to make a disclosure, right? I'm very direct and honest with kids about, when you shared that information with me, remember I told you I had to tell somebody about it. And the people I told are people whose job is to make sure that you're safe or to work on keeping you safe. And so they have this rule that after you share your story one time, then you get to go to this place. And remember, like language is important, right? It's not like you have to, it's you get to, or now there's this new chance to share your story again. This time it feels a little bit different because there's actually a camera that's videotaping you. And, and so the more you know about what that's going to look like and what that space is. And then we talk about like, again, you get to share as much as you want or as little as you want. You can tell your story again. You could read your story. You could read what you wrote to me, whatever that is. Usually they're not allowed to ask somebody to be in the room with them. But one kid I had who was really struggling with like bravery. And so I don't know how it evolved in session, but I ended up bringing him a like toy police badge and like police thing. And so he wore that to his CPC interview. And we sort of talked about like, what are some of the positive messages you want to put into your police badge so that, you feel empowered when you go there and you feel like you're able to talk about it. So using some techniques or some grounding and some safety toys with kids, like worry stones or anything like that. And then we talk about, here's what to expect when you disclose that, when you share that story again. And I usually try to say, like, the reason they want you to do that, the reason they videotape it is so that if you have to go to court, then you've already told your story. You don't have to say it again. And that's the truth, right? Then they show the story in court, and kids have to be in the room most of the time with their perpetrator, because the perpetrator has the right to confront the accuser. It's very unlikely that the judge will allow the child to be in a different room. Very unlikely. Which I think is ridiculous. But anyway, so kind of explaining, like, here's what will happen in court. They'll use that video so that you don't have to share your whole story again, but they might ask you things like, is that you in the video? Do you remember talking about it? So kind of like explaining that whole process to them, but in a very empowered way, not giving them false like resolution to it. Not that this is going to solve everything, or it's not going to be that bad, or because that's not real. So but just sort of like, here's why we do these things, here's why it's important to say these things. And the really cool part is, like, this courtroom is full of really important people, because their jobs are to make decisions about, ways to keep you safe and things like that. And you get to be a part of this group of people. So it's like that empowerment of, how do you advocate for yourself, and how do you see yourself as sort of your own hero or your own sort of advocate. And then also talking about, like, when you have to be in court, maybe the parent or somebody else can't be in there with you. And so here's what's going to happen with them. Like, when they're sitting outside of the courtroom, they're going to have a lawyer with them who's going to help them understand, like, what's happening in court, and when you're done, and then when you can see them. And so the child isn't feeling sort of abandoned or alone in that big process, because the more they understand all the pieces, the more they feel like they're a part of it. Not that they're like, kind of walking into this den of wolves. And so, and then I think the other part is, like, it's really important to follow up with them afterwards. Like, tell me how that went for you, or let's make sure that we see each other the next week and talk about, how did court feel? Or can you have mom or dad text me and let me know that, court is over and you were able to, not like you did a good job, because we don't put any value on it, but it's like, I want to check in with you. And that's like a grounding point for a child to know that, like, oh, and then when I'm done, you're still going to be there, and you're still going to care about what I said, and you're still going to support me. And I think that depending on what your role is, if, there's a line between leading the session so much that you make it your priority to always talk about that. I don't think that that's appropriate. But I also think, if court is next week, and you have been told this is what's going to happen, the child's going to have to disclose. In my opinion, I believe it is our responsibility, almost like a parent responsibility, to then prepare for that. So, depending on how you run your sessions with kids, I think, again, like, I think there's that line of, we don't want to be like always in control or always leading the sessions for our interest or for our comfort. But there are times that we have to hold the safety for that child, and we have to know what is best for them in that moment. When it comes to, okay, we could use this session for them to express their anxiety or be avoidant or whatever's happening, or how can I make room for that and provide some structure or some sort of parameter for them to practice what I know is going to happen in the next 3 days. Because obviously a child has no idea of how to expect that kind of thing. The other part I think is also within our responsibility is to advocate for that child. So some attorneys are really good about reaching out to the child or to the parent or the therapist and saying, you know, I'd like to have the child come to the courtroom to see it before anything happens. Or, I mean, some are really good about that and some are not. And so I think it's very appropriate if you feel for your child that your client's anxiety, that it would benefit them to go to the courthouse. It would benefit them to meet the attorney first or any of that stuff. I think it's totally appropriate for us to reach out to that attorney and ask for that. You know, that we're not necessarily ones who can do it, but it would be appropriate to say, you know, I know that this 5-year-old has a lot of anxiety about what this is going to look like. Would you, you know, is there a time that you'd be willing to coordinate with a parent to bring them in and let them check some of those things off? And then you could even, depending on how creative and engaged you want to be in it, you could make them like a scavenger hunt of the courthouse that they could take with them and then they could work on while they're there. But just something that makes them feel like they've been in this environment before, so they feel a little more comfortable and a little safer. So I think many of those things are ways to support what's going to happen. I think even just, you know, just little things like having the language to put towards things. So, you know, a lot of kids will come in and say, oh, my mom said that this person is going to come and talk to me, right? It's, again, I think it's appropriate to start to educate that child on, well, who is this person? You know, what is the job of a guardian ad litem? Why do they have such a fancy name? You know, why does a judge wear a robe like that? You know, like, why do they look the way they do? Because all of those things we all make up stories in our head of like why things are the way they are. You know, who knows what the child has taken and like created in that story. I know that some lawyers will talk to the child about where the child can sit so that the attorney can stand in between the child and the perpetrator in the courtroom as a way to add like protection. It's often helpful, depending on the safety, to help the child identify who are sort of the police officers in the courtroom, who are the people responsible for keeping them safe. There's the group, the Bikers Against Child Abuse, and they're amazing. If you're able to connect them with a child that you work with that has been abused, just kind of that feeling of having like you've got a whole group of people behind you and they're going to help you walk you into that place. And they do a really good job of preparing children for that. So again, that's how we work with the system, right? That's not just court, but it's reaching out to all of these other avenues and people that can help that child feel more comfortable, along with kind of what you do in a session. I also think it's important to let a child know that you work with other kids that have had to do this and other grownups. So they're not the only person who has had to go in court, and you know that it can be really scary or, you know, intimidating. But sometimes kids are like, what? You've worked with other kids that have to go to court too? So I guess in general about that, I think just having really direct conversations with kids about what to expect, about the names of things, is really, really important, because that helps give them words. Even, I mean, if they're 2 years old, right? If they're 1 year old, that's very different, because really your therapy sessions are not like cognitive processing. It's very sensory based. But that's when you would educate the parent on what are some security things that child would need, what are some sensory things that would help regulate that child. And your role could be to educate the courts on how trauma affects them from a sensory level, because that is often overlooked and sort of discounted. So, you know, I've for sure been questioned about, like, how can you tell a 2-year-old has PTSD, right? How can you tell this trauma has affected a 3-year-old? And educating the court on different types of memory, right? Like cognitive memory versus, body memory and somatic, and all of those fancy words that we use that we understand are not common language. And really breaking it down clearly about, here's what trauma is. The thing that I emphasize the most when I talk about trauma is it's perceptive, right? That it's a person's perception of their own safety. So that way we're not debating, like, do you feel like the child was really harmed? Or I don't know what happened to the child. I wasn't there. I don't know. What I do know is the child has expressed that they felt scared. They felt terrified. They were anxious. The other part that is very, very important when you're talking about children and advocacy about like trauma and is the idea of powerlessness and how significant that is in how a child functions. So talking about how children are dependent on their caregiver. Like, there's no debating that, right? A child has a parent because they need to have somebody help them survive. If that parent is unable to keep them safe, that child perceives that their safety is threatened, no matter what. And that can come out in like the child protecting the parent or, whatever happens. But really sort of educating the system on how children experience things is very different than how adults experience things. A child playing out a theme is a reenactment of trauma. So that is a symptom of PTSD. And so helping people understand that the benefit of play is using, toys and play are children's language. Those are the words that they use. And then as we raise children into the adult world, they learn how to adapt to our language, right? We're not teaching them language for them at 3. We're teaching them language for a 3-year-old to talk to us so that we understand it. And so as play therapists, we're trained to, instead of ask the child to come into the adult world, we are trained at how to enter the child's world and communicate with them. And play therapy is not an interpretation or an analysis of what's going on, right? It's not like, oh, the child is having one parent hit the other parent in the dollhouse, so I know for sure that there's domestic violence in the home. That is not what play therapists do. That's not what a child therapist does. But we look for themes and we look for how they resolve conflict, areas that they feel stuck or that they're anxious in. And so being able to sort of break apart some of those misconceptions or the things that you think people believe about your job, and how to use that as part of how to help prepare for what the child might say or what the child has said. For instance, I had a child who years ago, she's minimally disclosed sexual abuse from a stepfather. But what she would talk more about and what would like be more pervasive is she would remember like this disassociation she had when sexual abuse was happening. And she would talk about like a tiger coming in the room and how she remembers just like when she was in her bed, she would see this tiger outside of the door and she would see the tiger come in her room. And her stepdad, who was the abuser, had to work on fighting off the tiger. So, there's a lot of ways that could be misconstrued or sort of discredited to the child because she, number one, was identifying the stepfather as a hero in that moment, right? They could say like, well, she was delusional and that she had, all these other like attention-seeking behaviors. And so my job going to court was not to share what she said, but it was to educate about, the way a therapist could interpret her disclosure of that information is disassociation, and talking about like, the flight, fight, freeze, or fawn response, and how often in sexual abuse fawning is part of what children do, and they work on aligning and accommodating to make their experience safer for them. And so to me, that's not disclosing anything the child is saying, but that's really adding credibility to what the child might talk about. So the child doesn't have to modify their words. They don't have to have the right words, but here's what I know about how child respond to trauma. Even like a 2-year-old that I was working with, educating people on when a 2-year-old walks into a room that's full of toys and freezes and does not know how to engage in a toy, that is a strong indicator that they don't feel safe enough to feel curious. And curiosity is developmentally appropriate. So I'm not making an assumption that they were abused, but developmentally, there's something that's indicating a lack of safety in their life. So I think when you're asking about, children who are young, like the 0 to 3 age or 0 to 4, and kind of how do you support what they're saying when you weren't there, you don't know, those are the ways that you sort of look at what you know for sure about child development or a stress response, not just about theirs, but in general. And then sort of that A plus B equals C. What I know about this child is they would have this repeated image or experience where a tiger was outside of their door. And I know that children often disassociate and fawn in a sexual abuse experience. So that's as much as I would say. And often the people in the courtroom are respectful of like what you're not saying as well. I think it's really important to never, I would say never show drawings that children make. I think that opens up a whole bunch of issues. Number one, you're going to be questioned on like your analysis of the drawing, right? And that's not, none of us are psychics. So, number two, children don't always draw things literally. And so sometimes they try to find words to explain that may not really be like, they don't know, they're just trying to tell you about their drawing. So I, for sure, drawings in sessions, but I would never add the drawing to their permanent file. Same with the sand tray. The way I look at it is the people that I would share it with are not trained in it. So it's really like unethical for them to interpret any of that. If the child, let's say, did like sand trays and there was repeated violence in it, or there's repeated themes, I might document that the child continues to repeat themes of violence or unresolved. And then again, I can talk about like, why am I talking about a theme like that? What is that about? But it really prohibits then anybody from sort of having a different analysis of why the dragon is eating the mouse. Like, I think that's what sort of, I think as therapists, we get hung up on wanting to justify why we know what we know. But it's when we justify it that we actually open up the lack of credibility to some degree, right? Like the reason I put that theme in there is because that child has always identified the dragon as being like the father. Like when we start going down that path of our own analysis to a group of people who aren't play therapists, we're opening ourselves up to a lot of vulnerability, because it's like, when do you stop justifying that? Like they could tear apart everything that we're saying. So really try hard to only like support your statements with factual information or things that you know about child development, anxiety, trauma, and like kind of use your client's themes or statements or whatever you do want to share about your client, use that as sort of the introduction to what you're going to talk about, but support all of it with information that there is concrete, factual backing to, rather than the other way around. Does that make sense? Or is that not a clear way to understand it?
No, I think that makes sense, Kate. One of the things I think sometimes we talk to providers about, right, is what you were saying with the sand tray. And I like the way you expressed it, right? Of like, look, it's not ethical for you to look at this and make interpretations. We always talk to them about, like, we don't want anybody to be able to maybe obtain records or information, right? And so pictures become really relevant there, and decide on their own that they can figure out what's happening without needing to talk to you, right? And I think as we think about that objective of like gaining some confidence, right? Like really being able to take that one step further, right? And make that very true statement of, look, like, you don't have the training that I have. You cannot ethically make any interpretations or assumptions about what this means. Speaks to our professionalism and our training and our expertise. And so I like being able to say, look, I can talk to you, right, about the themes that I saw, but I'm not giving you these pieces.
I don't know if we really got to this last time, but a few years ago, I developed something called a parent-child relational assessment. And part of that assessment that we write uses the MIM video, if you're aware of TheraPlay. So we use the Marshak interaction method, and we video record parent and child interacting, doing some activities. Often, I mean, these assessments are typically used for court. So we're asked by the court, or contracted by them, to do this process of assessment. And part of sort of the, I don't know the right word, the glitch that has happened is that we have been asked many times to share the video of the assessment, right? Like, one attorney wants the video so that he can also say that his client did nothing harmful in this session, or one person wants it because they want to show how scared the child was in that assessment, all of those things. And it is a policy of ours that video is not shared or distributed to anyone at any time, because it is only used to be assessed or interpreted by someone who has been trained in how to interpret the MIM, nobody else. And so it's like the purity, or like the respect for anybody could watch any video of anything and take out pieces of it and make it totally irrelevant. And so I think it's super important to have a policy in place about, if you video record, if you have pictures drawn, if you take pictures of sand trays, any of that stuff, that no visual image or whatever you want to use will ever be disclosed or released. It is separate than the client's file. And depending on what you feel, like, we destroy the videos once they're done. So we don't even keep them for the ability to have them. And so I think it's really, really important to be upfront about that as a policy, because it protects you from the bat. Like, it doesn't mean that you're taking things out of the file. It doesn't mean that you're like withholding certain information. It's that, in that session, you had the client draw a picture so that in that session, you could utilize that picture. You could like process it, talk about it, whatever that is. You may take a note about what you processed about that picture, but not keeping the picture releases you from ever having it be interpreted or disclosed by anybody else. Does anybody have any feelings or thoughts about that, or feel like that's not practical? Or
Kate, maybe this is, I don't know if you'll have an answer to this. A million years ago, I remember somebody teaching that if it isn't in their, what we would consider like the hard file, right? If it isn't uploaded to their chart, but saved obviously in a confidential, secure way in the office somewhere else for the duration of the time that they're with you in therapy to reference back to or whatever, that's not considered something you would have to include in document flow. So if you know where the line is with something like that.
Yeah, I think it's tricky because I think you run into some credibility in that and just your ethical responsibility for transparency, right? So technically, yes, like if it's not a part of the client's formal record, but the way that I find that that's problematic is that when that client says, yeah, I drew a picture about it. Yeah, I was videotaped. And then you say, like, I don't have any record of that. That totally makes you less credible. And that becomes problematic. So then it becomes, why are you avoiding this? Why are you protecting? Why are you withholding information? Why didn't you put it a part of their permanent record? What is your policy on what you put in the record and what don't you put in the record? So it opens up this huge like discussion about where is it then and why isn't it there? And so I think that's why the transparency is so important, is that, I mean, technically, yes, but anybody could subpoena anything. Like they could come into my office and subpoena one of the toys I have if they need to use it for a reason. So it's really not protected, in my opinion.
Perfect. Yeah, that helps a lot.
We kind of have been talking a little bit about the ethical part of things, or just sort of some of the questions that are popping up. And I know that we went through sort of the guideposts that I talk about. Just as a quick review, how important it is in any sort of systemic work that you're doing to define your role. Like, who are you the therapist to? Who is your identified client? How long have you been meeting with them? What is your role in the meeting? My role here is to just observe what's going on so I can help my client understand it after the fact. Those kinds of things are really, really important so that you set your own parameter for yourself. Like, it's very easy, because we are compassionate people who want to help, to get pulled into something because emotionally we become invested. Like, I'm just at court so that I can support my client. And then, and this can happen at any point, because you're in the courtroom, somebody might say, oh, the therapist is here. Let's call them up on the stand. It's very likely that then we would feel like, oh, okay, then we have to go up on the stand, because we're put on the spot. We're in the courtroom. We don't really know what our parameter is at that point, right? You don't have to, because you're not subpoenaed. But reality wise, are you going to stand up and say, I'm refusing to go on the stand in that courtroom? Maybe, maybe not. Maybe that would be harder. So go up on the stand and then set your parameter. Like, maybe I'm not prepared to share anything today. I was not aware of court. Or, I'm here to be a support person. I'm not here to speak on my client's behalf. I've not prepared myself for that. I've not talked to my client about that. So just sort of knowing what your own role and your own parameter is really important in any situation you're in. We talked about being the expert and being very aware of what you are the expert in and what you're not the expert in. And the confidence to trust that you are the expert. And sometimes that does mean doing a little more research before you go into court. Every single time I testify, and usually when I'm testifying, especially as a professional testifier for court for cases that I don't know, I always review the criteria of PTSD. I always review certain things that I know I'm going to be asked about that I want to have the language to speak about. The other thing that I'm get caught up on every single time is the stupid stuff, like what year did you graduate? What year did you get your license? Blah, 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 all that stuff. So I always have my resume in front of me with all of those dates, because I'm not a date person. I don't remember dates well. I always have the client's birth date in front of me. Like just the things that really make or break your credibility. It's not that you couldn't say, I forgot, or I don't know. But when you think of somebody, wanting to respect what your opinion is, but you don't remember the date that you graduated, it's just not looking real good for you at that point. And then you start feeling insecure and you start feeling kind of tripped up and anxious. And so just knowing what are the things that I'm likely to not do well at or remember, and what are the things I know I'm going to be asked about that I want to have the language for. If play therapy, like the definition of play therapy, that might be something that you write out. Or whatever those things are that you feel maybe less confident about, because it doesn't take away the fact that you still are the expert. You just want to help yourself present as the expert. Staying in your lane is really important. And we've talked quite a bit about that, kind of what is your lane and what is not. Your ego check. And this is, kind of the overconfidence, but also like that insecurity or that underconfidence, like, well, I don't really know that I'm an expert in filial therapy, right? Yeah, so maybe you're not trained in that type of therapy, but you can talk about what it is, or you can talk about that you've practiced it because you've observed it, in so many sessions. So just kind of like knowing how to not let your ego get the best of you in either situation. Knowing yourself, like knowing what are the things I need to bring with me in a meeting. If I know that like I'm going into like a family team meeting with an attorney who's really difficult, like really obstinate, I truly have to give myself a little bit of a pep talk about not getting too snarky, because I do, like, I know this person just like gets under my skin. And I just recently we hosted like a big family team meeting, and it was about a 14-year-old client. She was there and family members were there, and her parents' attorney continued to refer to her as the ward and not use her name. And it was so irritating to me and so disrespectful, because he kept saying like the ward, and she's right there. And I felt like at that moment, I'm her therapist. I also feel like it's my job to like protect her from being disempowered or, disrespected. And so it took me a lot of restraint to just stop the meeting and say, can we please use her name? And then there was like the sigh of relief around the room, because everybody was feeling it. It was like ridiculous that this person's calling her the ward. And the client didn't even know what that meant, but I felt like at that moment, like it wouldn't be ethically appropriate for me to allow that to continue and participate in that when I feel like that's disrespectful and disempowering to my client. But I also had to walk that line of like, but I can't get, hostile or like parenty or overprotective, because that's also not ethical for me to, swoop in and like defend, because that's, it's kind of this line. And so being very aware of like, what are the things that are going to trigger me? I'm already walking in feeling snarky at this guy, so it's not going to take much for me to feel angry. Knowing that my client was in that room, right? So like I maybe had a different responsibility because she was there. So just knowing that and knowing what's appropriate in your role, and trusting that your opinion is wanted. People really want to hear what you have to say. So we're just going to jump ahead to assessment. So the most important part about this category, because obviously not everybody is crazy like me and decides to create something that's like a 14-page assessment. It gets longer every time I write it, which is a little bit ridiculous. So understanding that not everybody's going to do that, it is also important to know that you are qualified to do any kind of assessment that you sort of design, right? The important part about calling it assessment is that we're constantly assessing. every session we have, we're assessing the needs of the client, what their behavior is, what's going on. We sort of discount that as like being an actual assessment or formal enough or, like legit, because it's not. Maybe we don't use standardized testing, or we don't use any kind of research-based gathering of criteria or information or statistics. So all of those things do make assessments credible. But if you were to say, I've assessed this client based on my observation, based on the client's participation, based on the parent's assessment or observation of the client, and here's what I found, that is a credible assessment. What's important about an assessment is you have to be clear about what your observation, like what you're observing. Is it the client's report of something? Is it diagnostic? Do you have your training? So again, you have to build your parameter and your structure about what you've assessed. That's how you make it credible. It doesn't have to be something research-based. It doesn't have to be, a 3-month study of something to prove it's an assessment. But again, you have to stay in your lane and make yourself credible in it. So, what are the tools that you've used to assess? What has been like the information that you've taken into it? What have you conducted from that assessment? So in your session, you may have spent 3 weeks assessing the child's ability to self-regulate. So then you would just want to say, like, what are tools that I use to measure that? Is it based on my observation? Is it based on, do I take their heart rate and talk about like self-regulation and what your body does? As long as you're saying, like, here are the tools I've used to assess that with, and here's my observation, and the result means, it doesn't mean that the child has anxiety, because maybe that's not what I was assessing, but I can say that the child appears very dysregulated when I meet with them at this time. And I can say that based on, here are the ways I've measured that. We wouldn't want to say, I can tell that the child has post-traumatic stress because they've been dysregulated in 3 of my sessions. That's not a comprehensive assessment. That's not really like aligning. And I think that's what creates a little bit more like speculation or discreditation about what you're saying. But there's also a benefit to making it something that, yeah, this is an assessment, right? I've assessed what this looks like. Again, giving yourself credibility and professionalism by using the words that you can. Diagnosing a client is an assessment. You are all trained to do that. Many times in court, you're asked, like, how are you qualified to do that? And then you got to talk about like what your educational expectation was in school. But knowing that, I'm not trained in any kind of like psychological formal assessment, but here's what I have been trained in. Here's how I have built my credibility in it, and trusting that that does make you credible. It doesn't that you have to do the same kind of testing that the psychiatrist or the psychologist does. And so when I developed the parent-child assessment, I had to really look at like, what would make me feel like I'm an expert enough to say that I like am confident and qualified that this assessment is legitimate, it is going to provide good information. And some of the things that I did to make sure of that is I did incorporate a tool that I was trained in, I was like certified in, and it's a tool that there is, it's an evidence-based tool that's been used. It's something that anybody could learn about, anybody could use, and it's a part of my assessment. So I've like taken that piece. I've used some checklists to like support the client's perspective of things. So they just document on a checklist and things. I use the ACEs. And so I have like this collection of information that I feel that I've like, kind of like looked at all the avenues to build up the credibility. And I've also made sure that I've done the work to make sure that I have like the criteria to say that I am able to do this. It's just like you've done the work to say you're able to diagnose certain things, but maybe you're not comfortable saying you can diagnose dissociative identity disorder. Maybe you don't feel like I have enough training on that. And so then you wouldn't do that. So reminding yourself that everything you do is an assessment, even if the client reported something and you've assessed something. It doesn't have to be kind of what we think of as the criteria to meet an assessment, if that makes sense. Does anybody have any questions or like discussion points about the idea of that assessment? Or does anybody use assessments that you kind of want to like share or talk about how you've developed those?
I was just gonna say, Kate, I really like the kind of the explanation, right, of that we're really in essence constantly assessing, right? And so knowing, I know our providers have several formal assessments available to them so that if they want to utilize those are available to them, but not kind of underplaying just those day-to-day interactions that we're having with our clients and that constant assessment, especially in play therapy, right? Where we are looking for themes and changes in those themes and behaviors, right? That don't lend themselves always to, you know, a neat little box of kind of the more standardized adult formal assessments.
Mm-hmm. And there are some, you know, like books or some, I guess I'd say workbooks, but like there's the trauma-based play assessment by Ileana Gill, I think. I have it on my bookshelf. So that's just like a 10 session or 12 session. Basically, there's 12 sessions laid out for you, right? Of what to do with kids. That's play-based. And then she gives you sort of the way to put it all together as like an assessment of the child's readiness to talk about trauma. So, I mean, again, she has supported it with her information and her literature that she's read and maybe like the things that she's pulled from. But I would guarantee that 50% of the activities that are in that assessment are things you already do. So because she put it in like a box and she put it in the structure of here's why I chose these activities, here's how we're going to like look at them and what we're going to apply to understand them. And then here's the expected outcome. It's not going to diagnose the child for me. It's not going to, you know, give me a solution to what's going on, but it will help me determine their readiness. I think that's a very appropriate use of an assessment as a therapist. And so finding tools that you feel like are very, they kind of give you that structure, they give you that backing to say, yeah, I applied this tool. And here's why I used it. I use 5 drawings with kids almost, and like the beginning of my relationship with them, I have them do 5 different drawings. And those are play therapy or art therapy assessment tools. They don't conclude anything for me. It's not like they have the solution. And then because they did all these 5 things, then we move to, you know, level 2 of whatever. It's just me assessing certain areas of their world. And so like one of the things is called a pipette drawing, if anybody's familiar with that. It's a child or a person. You ask the child to draw a person picking an apple from an apple tree. And it's used to look, and again, I mean, you can use it for many other reasons, or many things can also come out of your discussion of it. But the intention is to look at resources. So how does a child, you know, do they put a lot of apples in the tree? Do they have the person carrying a bucket up to the tree with them? Is there a ladder in it? Are their feet on the ground? You know, all of those things. And there's no like diagnosis that goes with it. There's no specific thing, but it gives you an idea of how that child perceives their ability to access resources, the support they feel in those resources, Would they have somebody help them? Would they not? And it's a discussion that you have, like, again, we're not analyzing the drawing, but we're using it as a discussion to talk about that. So that's an assessment, right? It's an assessment tool that I use, and I would talk about why I would use it, but it does make it credible. So my guess is that you are probably using assessments all the time that you just really haven't said to yourself that they're assessments. But that can also add some credibility or even some structure to how you approach a session or how you share information with a parent or with the DHS worker. It gives you a little bit of like kind of that parameter that can be helpful. Any other feelings or thoughts about that?
I was going to say that one way that I'm assessing with kids is like their potential nervous system states. And I'm using different behaviors to look at what potential nervous system state that they're in, if they're in a distal state or if they're in a parasympathetic state. That would be something that I would need to brush up on prior to going to court, and just making sure that all of my notes are like in alignment with looking at those observations, and that they match up with the different nervous system states. Sometimes it's relevant, sometimes it's not relevant. So I don't necessarily like include that in the notes, but I am including like how quickly the kid is breathing or how slowly they're breathing, like the pressure of their voice, how quickly they're speaking or how slowly they're speaking, rapid movement or slow movement. And so that's like one way that I'm assessing what's going on with the kid for that day.
For sure. And I think that's a great idea is you kind of have your measurements, like, what you're looking at. Maybe you have sort of a protocol in your own mind of like, well, these are the areas that I typically will check in with at a certain point. So you collect this information and then you make your educated assessment from that. And that's really appropriate. I often use a pulse oximeter in my office to measure just heart rate and look at stress responses. And so that doesn't mean I have to be qualified as like a medical doctor, but I can look at a pulse rate, but that kind of like specific criteria that, like you said, their breath or their, whatever that is, if you have a measurement that you're looking at with it. So here's a scale, here's what it indicates. If their heart rate's at this certain level, that indicates that their stress response system has been activated. And then I have some documentation that, their heart rate is always at 110. I'm not diagnosing again, but I'm saying they seem to carry some somatic dysregulation. That's a fair assessment. One thing, the way sort of the parent-child assessments came to me was I was asked by a guardian at LISW to assess the mental health of a 2-year-old. And it was really tricky because for this child, her infant brother had been dead in the home for a week, and that child was living in that environment. And so obviously the guardian at LISW wanted a way to assess, like, how has this child been affected? How do we know what was going on with this child? And also sort of like an advocacy for this infant that had died of like, what in the world was happening, But this 2-year-old who even developmentally was younger because of the trauma that she experienced, how do we diagnose or assess for mental health? And so what I know and what I believe in is that, at that age, it's developmental trauma, right? It's relational trauma. So we can't look at it from a diagnostic perspective. Well, the traditional diagnostic perspective. We have to look at it from like a relational perspective. And so how do we do that? How do we do that when both parents are going to be probably arrested, but are very uncooperative, right? This child's in foster care, like all the moving pieces in the system. And so that's kind of how the parent-child assessment came up, was like, I got to find some tools that I can use to look at not necessarily like what happened to this baby or any of that, because I don't know that, but how can I help this child and the child who died moving forward, right? I'm working on what's happening now to prevent more trauma from happening. And so that's how the parent-child assessments were developed. And it really allowed, I think, for an opportunity to help educate the system on how significant the relationships that children have with their caregivers affect their mental health. So instead of at age 3, you're going into court and people are really struggling with why you diagnosed this child with post-traumatic stress. Okay, the DSM does not have a very good delineated area for 3-year-old post-traumatic stress. So most people don't even know that it's in there, right? So educating on what is developmental trauma, why is it so significant? You know, getting out all your Bruce Perry books because he's got all the information in there that would support it. Learning about theraplay and about relational patterns and all of that stuff. Putting all that stuff together and then being able to say, when I observe this child interacting with their foster parent, when I observe this child interacting with their birth parent, here are the things I'm seeing. Here's what I know that children need developmentally at that age. And here are some things that I think would help this child have a healthier relational pattern, have a healthier mental health. It doesn't mean that I'm, saying like they shouldn't be with their parent. It just means that this is what I'm seeing. And what we know for sure about relationships is that if they don't feel safe, a child cannot developmentally grow. And so, I think that there's a benefit to being able to put some of that stuff that we just know because of our education into a formalized assessment that we can share that information with somebody who may not know that. So for instance, in that assessment, this is just a little part of it, but the presenting problem was by the attorney. Oops, sorry. They requested that parent A and the child receive an assessment to determine the parent's ability to appropriately respond to the emotional needs of the 4-month-old daughter, of his 4-month-old daughter, child B. Exploring the level of attachment within the parent-child relationship allows for areas of intervention to be identified as well as areas of risk and potential risk. And then the needs that are determined is that child B, and then I highlighted, like, how did I come up with this information? By history, by parental observation, and by my personal assessment, displays a somewhat disrupted attachment. However, it should be noted that she is young and maintaining stability with her primary caregiver will allow for her attachment to become more secure. It appears that her attachment to her father, parent A, is healthy and can continue to be fostered. Child B appears comfortable and trusting of parent A, as evidenced by her calm demeanor, her ability to feed, her body's ability to be regulated, and her developmental age. Child B would benefit from one consistent caregiver who is able to be both physically and emotionally present with her. Parent A displays the ability to be consistent and nurturing to child B. And then recommendations. So like, what is the benefit of the assessment? And it's part of that education that it's thoughtful. It's recommended that thoughtful consideration regarding child B's permanence should be taken into account for these reasons. It's of concern that parent A's lack of insight and significant trauma history, difficulty regulating and expressing emotions could contribute to him being overwhelmed, anxious, and easily frustrated. So it lists all these sort of pieces that we took out of that assessment without making any kind of formal determination of, is this parent a good parent? Is this parent the place where the child should stay? Is the parent negatively affecting the child's mental health? We don't get to determine all that stuff, but we can say what we know about child development, what we know about what we've observed, what we know about mental health, and putting all that together in sort of a package for people. And you support it by what you know. You support your assessment, like the conclusion of your assessment is supported by what you know as a professional. Any other questions or thoughts about assessments?
It makes me nervous that just the idea, Kate, of like creating our own assessments, because that means that other people could just like create their own assessments, you know? like
Yep.
so then it's like assessment versus assessment, and like logic of how you created those assessments, I would guess, is like the next step of things. So yeah, I guess that just lets me know that it's super important to like have reasons behind why you're using the certain assessments that you created yourself, because
And I think along with that, I think you bring up a really good point. And along with that, it helps you recognize that you have to be more discretionary about what assessments you do use that other people have come up with, right? Like there are millions of assessments out there that we can go use and apply, but do we know how it was developed? Where, like what perspective it was developed from? What is it actually intended to measure versus what are we using it to measure? Right. So I think you're right that the credibility of an assessment and the person that developed it is more important actually than what you're assessing, because you are like kind of putting your trust in the information that you've collected into something else, into like a determination as to where it comes from. And so I think that if you do create your own assessment, keeping that in mind is very important. You know, can you lay out the credibility that you're using to support your assessment? I think that's just as important in your assessment than the result of it. Is like, what is this actually measuring? What is it not measuring? Why do I believe this is effective and appropriate to use? And setting those limits. I don't think you were here when we talked about um, setting the limits about what information would you share outside of the assessment and what wouldn't you, right? So I use a video in my assessments, and that video is not shared to anyone else afterwards because nobody else is qualified to watch it. They would look at it from a different perspective. And so being very clear about what are the parameters around your assessment, right? I'm the only person in the state that does my assessment. My interns help with it. But I'm very hesitant, right? Because part of the credibility is the experience I've had for 20 years. I've been asked to teach it to other people, and I don't know how to do that. I don't know how to teach my assessment. I can teach how to conceptualize my assessment, how to think about things like this, but I can't teach it because a lot of my credibility comes from the experience that I've gathered over time. So from what your assessment is about like the stress response system and all of that, you have a lot of credibility, a lot of training, a lot of experience, a lot of ideas about how you can put all that together. I think that's how you sort of protect it, is like not make it something that everybody can facilitate or that everybody's looking at or that applies to all of your clients, because it may not. Using discretion ultimately is really important in it. And I think maybe the hottest topic is the testifying part, right? Everybody wants to hear more about testifying. So um, we've really kind of uh, sprinkled testifying stuff in the entire two parts of this presentation. So I think what's the best thing to do is if questions come up during this section, let's prioritize those. Let's bring those up first. Because I do feel like a lot of this information we have touched on just in different areas. So recognizing that testifying, knowing if are you testifying as an expert witness or a factual witness? People sometimes intersperse those terms, right? So the way that I use those terms, right? If you're an expert witness, you're testifying about your professional training, your like analysis, your work as a therapist for a client. So your diagnosis or what you've observed in sessions, that kind of thing. A factual witness has the client shown up to all of their sessions. You have facts to support that, right? So that's how I determine the two differences. And then there's something called a blind witness. which is like a blind expert. So that's what I do throughout the state. I testify about cases that I'm not connected to. So I testify about information that I'm an expert in, but I have no relation to the case. So I might be asked to go testify about child development or how trauma affects a child's brain. But I know nothing about the case and I can't. Like it changes my role if I know anything about the case. Or I'm asked to come in as an expert witness on a case that I'm working on and talk about how trauma has affected the brain of my client. So kind of thinking about when you are asked to testify or clarifying with them, what are you being asked to do? What is the role that you're in? Before you agree to be in court, know your role and what they want you to talk about. Always have that conversation with the attorney beforehand. If they don't reach out to you, it is very important that you reach out to them ahead of time. Do you know what you believe in? So do you know kind of where you stand? Again, when you are the expert testifier, it is about what you believe. It is about your opinion. It's about a professional opinion. It's about your opinion that you can back up with things that you know, but it is about your opinion. It's not just about the facts. Do you know what lane you're in? And review with your client kind of about testifying. So I always, it's important to share with your client that you'll have to testify, whether they're an active client of yours or not. Because again, your priority is the relationship with them. But some benefits to testifying is that it takes the burden off of the client, right? They don't always feel like they have to be the one to have to say all the stuff or explain their mental health or whatever that is. Remind your client of their privacy right, that even though you are subpoenaed, they still have a way to have privacy in this, and talk about kind of how you're going to do that with them. And remind them that you will be under oath and will be questioned by both people. So even if their attorney has already told them what they're going to question you about, remind them that there's another attorney that can question you about anything else. I think it's totally appropriate many of the times to offer a letter of summary rather than testimony or case notes. In my opinion, I would opt to testify before I would opt to turn over case notes, like hands down. Do you really believe that you can offer something beneficial to testifying? Just recently, I'm going to be subpoenaed for a case that I had like 3 sessions with 5 years ago. And so they want to testify. They want me to testify. And I really don't believe I will be of any benefit. And I think it will be financial burden to my client or to my former client. And so I think it's my ethical responsibility to share that with the attorney. Like, I'm not going to help. Like, the information, here's what I would offer to you. And I really don't feel like it's worth that. That's still my opinion. They can still subpoena me. But I think it's my ethical responsibility to be transparent about that. There's no sense in my former client, spending $1,500 for me to say nothing that will be beneficial. I think it's important to talk to your client about how it affects trust, how it affects them financially, how it affects time, because all of those things, they're not our responsibility. But if all of a sudden our client gets a bill for $1,000 and they weren't expecting that can significantly harm your relationship. You have the right and obligation to speak to the attorney before you're subpoenaed, or once you're subpoenaed before you show up. No matter what, even if you're under a subpoena, you must get a release. You don't get a choice if you're subpoenaed on something factual, like, so if DHS, if you made a report to DHS and you're being subpoenaed to say, like, yes, I made the report, this is the day I called, there's not much wiggle room for you to get out of that subpoena, because they just need you to say that happened. You don't have a good, argument there. But it's a little bit, it's a little more necessary to find a way, if you really believe that what you're subpoenaed for is not ethically appropriate for you to talk about, or it would harm the client. It's necessary then to figure out, kind of, I don't feel like it's appropriate for me to be subpoenaed, or you can have that discussion with the attorney. Chessie, did you have a question?
Yeah, it was just a few different things that I'm confused on the logic about. So I was hoping that you could clarify for me. So you're subpoenaed by an attorney is different than being court ordered to speak about something. But if you are court ordered, you still have to get a release. Or is it just if you're subpoenaed by an attorney that you must still get a release? Because what if they don't give you the release?
So the court order would, I guess I look at it like the judge signs the court order, right? So the judge says, yes, I agree that this has to happen. But there is always an attorney involved in that mix, unless for whatever reason, well, I'm not even going to say that. If your client is involved with court, there's an attorney, period. So there's an attorney for the state, there's an attorney for the child, whoever that attorney is. And that is the person who well, you can't contact the judge and talk about your subpoena, because that would be unethical for the judge to have that conversation. So what your responsibility is to find the person who would be, in my opinion, aligned with your client in some capacity, because that is, again, like that's your best, well, that's what your ethical responsibility is how is this going to affect my client? So to me, that is where you would sort of navigate those questions. No matter who subpoenas you, or if it's in a court order, there is a way to like squash that. There's a way to reject a subpoena or a court order. I don't advise doing that. It's hard to do. Well, it's not hard. It's just, it can take a lot more time to do that than actually just have the conversation with the attorney or show up to court and then, use the stuff that you're learning to share what you're comfortable with and share what you're not comfortable with. Is that clarifying what you're asking, Chessie, or am I missing something?
No, that makes sense. So you're still saying like what I've learned from grad school about like making sure to get a release before talking to the lawyer.
Mm-hmm.
But if it's court, what I'm asking, I guess, which is not listed here, is if it's court ordered and you request a release from the client and they don't give it to you, isn't it still court ordered? But you're saying that there is a way to like say that could be harmful to the client.
Yes. So then what you would, ultimately what you could do if you can't figure out what to do because you're not getting the release signed or you're not able to quash the subpoena or whatever that is, then you go to court anyways. And then you say on the stand, ethically, I have not been able to obtain a release from my client. I feel like it's not in their best interest for me to share anything. Basically, here's what I can share without disclosing things that I'm not comfortable with. You can write a letter to the court. You can, if that's the case, let's say the court is like 3 weeks away or 4 weeks away. You can write a letter to the court, to the judge, to the, and you can say, basically I'm declining the subpoena because my client refuses to sign a release, because it's my ethical responsibility to have a release first, because I believe going against that would be detrimental to my client. But you have to put out your information. It doesn't mean it's going to be honored. And you cannot not go unless you've heard a response. So if you get a response saying, we respect that, basically we're going to cancel the subpoena or the court order, you need that in writing. But if you don't get a response, maybe you don't know what happened to the letter, who knows? You can bring that copy of the letter into court. And then that's what you're testifying is, here's what I've attempted to do. Here's what I've tried. And because I haven't gotten a response, here's why I'm not. But thinking about all that, which I think there's a time and a place where you need to do that kind of thing. Like that is where you're at. It does take a lot of time and a lot of effort. And so if you're trying to not testify because you just feel like you don't want to, or because whatever those reasons are, you are going to invest a lot of time refusing that as well. So sometimes not refusing it, and this is where you lean in to what you're comfortable with. Like you show up and you're fine talking about the attendance of the client, you're fine, whatever that is. But when you're on the stand, then you say, sharing that I believe is against what's in my client's best interest.
And then are you saying that even if your client doesn't provide a release, you're still charging them legal fees because you're required to be in court?
So for us, if they're involved, this is just our policy, but if they're involved in DHS, so if court is because of something that it's not a private matter. So if it's like a child was abused and so they have to go to court and we're subpoenaed for that, we typically don't charge. If it is a private matter of any sort, like custody or parents asking to modify, whatever, divorce, whatever it is privately, then we send the bill to the attorney who subpoenaed us. And typically then that's what the attorney then has to deal with, like the financial part of it. The attorney's office has to pay us because that subpoena is it's like a binding contract. But it's also important to be upfront about what your rate is and what that will look like.
Okay, that's helpful because I feel like if a family didn't provide a release of information, but I know what my legal fees are upfront if I'm court involved, I feel like that would definitely mess with the relationship. But they know that from the get-go, even prior to consent, they know all of the financial fees.
Right.
I just feel like that release of information bit maybe could be confusing for some people about whether or not it starts the legal fee or if it doesn't start the legal fee. So I wish I had access to your paperwork.
I think the important part about that is that, remembering that your client is always going to be represented by somebody. So if you get a subpoena, even if it's a court order, right, it's about a client and your client will be represented by somebody, whether it's the state, whether it's a private attorney. And so that's where you can kind of have that contract or navigate what that looks like. So if that client's refusing to sign a release, then you contact the attorney. You don't have to disclose information except the person I'm subpoenaed by is refusing to sign a release. That attorney can help navigate that. That's kind of your chain of communication there.
Got it. Thanks.
Yeah. Remember not to put details of information in your notes. We talked about pictures, things that can be interpreted differently. And always review and fine tune your notes. That doesn't mean change your information. That means look at your spelling and look at things like that. And black out any kind of information that you feel would be detrimental. Even if it's some 2 sentences in a note that you put in there something about a different person, or, maybe you talked about their sibling. That's not relevant, or that's not covered in a sense that what you want to talk about. And then you'll just have to talk about why you blacked it out, which is fine, but you're protecting your client without withholding information or even changing a note. Erasing something is not okay, but blacking it out is okay. And then just some quick tricks on testifying, since I know we're again running short on time, but we're almost done. Just make sure you just answer the question. That's all you're supposed to do. Like if they say, do you feel like your client willingly walked to their parent? The answer is yes or no. or I'm not qualified to answer that. It's not, yes, but they seem anxious when they do that. Don't ever offer more than what you're asked. If they want more, they will ask more. But that's really important. Be sure to clarify your role to all parties. Remember that you're not making any decisions on the stand, none. Take your time. Be prepared to defend anything you say or have written. If you don't want to have to do that or you can't defend it, don't write it. So be very thoughtful about that. Testifying is safer than releasing records because you have a chance to determine what you share and what you don't share and clarify. When you release a record, it's like free game in a sense. It's okay and necessary to say things like, I'm not qualified to answer that. I do not have an opinion about that. Do not try to avoid the question. Answer directly. You can say things like, I don't know. It's not within my role or scope to answer that. I don't understand what you're asking. But if you start feeling uncomfortable because of the question, then just say, like, I need clarification. But don't try to avoid it because that changes credibility for you. And you usually end up saying something that you don't want to say. It's also okay to separate the question out. Like kind of ask them to separate it. Use your own language, not theirs. Don't let them put words in your mouth. Refer back to your role, your expertise. Set your own limits. Remember, none of it's personal. They're just doing their job. Trust that you know more about this stuff than most people in the room, and that's why you're there. Speak in generalities. Don't let them pigeonhole you, and that happens a lot. So saying something like, children who've experienced chaos in the home display versus Johnny is reacting this way because of his parents' instability. So you're still answering the same question, but if you speak in a generality and then you add what you've observed, that's what you've kind of done the A plus B equals C. It gives them, they can determine how they want to interpret that information. You're not interpreting it for them. We won't necessarily go through the Court of Appeal stuff. It's not as significant. The last thing I like to just keep in mind is I think it's really important if you know you're going to go into court or like a hostile family team meeting, think of yourself entering like the wrestling ring, right? Or like at the football field. And like, what song are you entering it to? Right? What's kind of like your empowerment song? What do you want to remember? Or maybe like a mantra, and bring that in with you. Like, I mean, figuratively or quietly. But it's really like, it's like putting that cape on before you run into the ring. It's like you have all of the stuff you have with you. You know what you need to do. And now you just need sort of that, like, all right, I'm here. I'm going to show up. I'm going to do my job. What do you need to have that sort of support behind you? I like to think of the song Girl on Fire by Alicia Keys before I enter the courtroom, because then I feel very confident about what I know, and that I am the expert. So what will you need in order to stay regulated, supported, and confident when you enter? All right, I think that we have like time for maybe one or two questions, and then we're done.
You briefly mentioned earlier that I think I caught it, that the court order is basically an agreement for the attorney to pay you. Did I catch that right?
Yes. Well, it's an agreement for the court to pay you. Well, it depends on how the court order is written and what it's for. So, like, for instance, I get a court order to do the assessment, right?
Mhm.
I can submit a bill to the court or to the payer because I have the court order, because if it's in the court order, that secures, like, since the court ordered it, the court recognizes who's going to fund it.
Mhm. That makes sense.
You'll want to clarify. I don't know the short answer to that. I just know that, like, in the things that I've been court ordered for, which I've never been court ordered to testify. I've been subpoenaed to testify. But if I've been court ordered to do an assessment, or I've been court ordered to be a for consultation, then that court order is what secures that payment.
Okay. And that would be different than a subpoena. A subpoena is just you have to show up. I got you. Okay. Thank you.
Yep. It is important, though, to always have a court order or the subpoena in your file, because it also shows that you're not the one choosing to do this. Like, you didn't just volunteer. It means that the court has ordered it for a reason. And that's just helps, again, ethically, to show that like you're not biased in what is happening.
I feel like it also just shows that you're keeping the privacy of your clients. You're not like, hey, I'll show up in public for you.
Exactly. Exactly.
Such great information, Kate.
Good.
I really appreciate it. I appreciate you guys joining us for part 2, because there's so much to kind of become comfortable with, right, with the courts, and it's not something that I think anybody walks into this field like super excited to do and be a part of, but increasing that confidence and that awareness of what that court system looks like and what our role is within that is so helpful. So thank you again, Kate. I did link the quiz for today as well as the evaluation in the chat box. If you have any issues following the quiz, let me know, but you should be issued that CE certificate immediately after that. So I really appreciate everybody being with us today.
Can I just add really quick to you? We have a few trainings coming up as well. So if you're interested in just getting like our newsletter or knowing what trainings we have to offer, please feel free to, my email is on the front of the slides. Just email me your email address so that I can add you to our mailing list, or check out our website, because there's some information coming up that,
Absolutely. And in the recorded version, Kate, I'll go through and grab that information in that email list so that it's linked there for them as well.
Great.
Perfect. Well,
thank you
all very much. Yes, thank you.
Thank you for joining in on today's training. We look forward to having you join us again. Heart & Solutions is proud to provide CE-eligible trainings for our counseling community. This training may be eligible for continuing education credit hours through either the National Board for Certified Counselors, provider number 7376, or the Association of Play Therapy, provider number 21-645. To obtain CE hours for today's training, be sure to follow the steps in the description below.